and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we update you with the recent important legal developments across the nation. Let's take a look at the headlines. Plea seeking review of same-sex marriage verdict mentioned before Supreme Court for open court hearing. Supreme Court to hear challenge against sedition law in January. Parliamentary Standing Committee advocates caution in embracing technology in legal proceedings. Union government initiates probe into alleged violations by electric two-wheeler makers under FAME 2 scheme. Justice M Fathima Beevi, the first female judge of Supreme Court of India, passes away at the age of 96. Now the headlines in detail. In a recent development with regards to the plea seeking the review of the same-sex marriage verdict, the petitioners mentioned the petition before the top court for open court hearing. The petitioners in the case sought the review of the 5-judge Constitution Bench judgment delivered by the Supreme Court on October 17 this year, which declined to grant marriage and adoption rights to queer couples. The matter was mentioned before the Apex Court today by senior advocate Mukul Rohatgi, seeking an open court hearing of the review petition. The bench headed by the CJI D.Y. Chandrachud and Justice J.B. Pardiwala and Justice Manoj Mishra agreed to consider the plea and stated that all judges agree that there is discrimination. If there is discrimination, then there has to be a remedy. The court then listed the matter for November 28th. The CJI also said that he will examine the request made by the petitioners and take a call accordingly. In retrospect, the 5 judges, namely the CJI Chandrachud and Justice S.K. Kaul, Justice S. Ravindra Bhatt, Justice Hema Kohli and Justice P.S. Narasimha, were unanimous in refusing to give legal recognition to same-sex marriages under the Special Marriage Act and made the observation that it was the centre's prerogative to change the law for validation of queer marriages. However, the Apex Court by a 3-2 majority held that queer couples do not have the right to adoption. The Supreme Court has said that it will take up the batch of petitions challenging the sedition law, underlined in Section 124A of the Indian Penal Code, in coming January. The Chief Justice of India D.Y. Chandrachud mentioned that an appropriate bench would be constituted to hear the case. In August this year, the central government introduced a bill in the Parliament, which sought to replace the existing criminal laws that are prevalent since the colonial era. The bill, among other things, proposed to repeal the sedition law. However, the top court has clarified that despite there being the introduction of a new law, their application will be prospective in nature, meaning it will only apply to future cases, while past cases would continue to be prosecuted under the existing provisions of IPC. The Apex Court had earlier underscored the necessity of establishing a constitution bench of at least 5 judges to deliberate upon the challenge to sedition law. The decision was prompted by the historic validation of the sedition law granted in 1962 in the case of Kedarnath Singh. The central government had previously sought a deferral to the examination of the validity of sedition, citing the bill being under consideration of the Parliamentary Standing Committee. The Supreme Court, however, rejected the centre's plea, emphasizing the imperative for constitutional scrutiny regardless the proposed introduction of a new law. In a previous order, the top court also suspended temporarily the enforcement of sedition laws, urging the central government and states to refrain from registering case under Section 124A. The court has also questioned the rationale behind retaining the said law even after 75 years of independence. The Parliamentary Standing Committee on Home Affairs, led by MP Brijlal, has lauded the push towards integrating technology into legal proceedings. It also hailed the move of enabling online or electronic FIR registration as a positive step forward. However, the committee has emphasized the need for stringent safeguards and establishment of a robust mechanism before widespread implementation of electronic means for communication and trials. The committee conducted a thorough examination of the 3 proposed criminal laws, namely the Bharatiya Nagrik Suraksha Sanhita, the Bharatiya Nyay Sanhita and Bharatiya Sakshya Adhiniyam. One key provision under scrutiny is Clause 532 of the Bharatiya Nagrik Suraksha Sanhita, which allows electronic trials, inquiries and proceedings. The committee raised concerns of potential misuse and manipulation of electronic evidence and expressed worry over the data security and unauthorized access. While it acknowledged the benefits of technological advancements, it said that the above concerns prompted the committee to recommend a cautious approach. The panel also highlighted the concerns with regards clause 173 of Bharatiya Nagrik Suraksha Sanhita, which provides with giving information of commission of a cognizable offence, whether orally or by electronic means. The panel said that it could become difficult to track all FIRs, especially if, for example, sending an SMS to a police officer is considered as providing information under clause 173. This, the panel said, could create logistical and technical challenges for law enforcement. The Heavy Industries Ministry has launched an inquiry into a reported violation by officials and two-wheeler manufacturers, accusing them of claiming incentives without adhering to the norms of the FAME-2 scheme, short for Faster Adoption and Manufacturing of Electric Vehicles scheme. This investigation encompasses a total of 7 companies, including prominent names such as Hero Electric, Okinawa Autotech, Ampere EV, among others. The inquiry also seeks to uncover the alleged involvement of validation and testing agencies such as Automotive Research Association of India and International Center for Automotive Technology. These agencies were tasked with examining whether the companies are following the phased manufacturing program localization guidelines. However, there are alleged lapses by the officials involved in the process. The centre is now seeking a refund of incentives worth Rs 469 crores from the 7 companies violating the norms of FAME-2 scheme. Justice Fathima Beevi, who was appointed the first female judge at the Supreme Court of India, passed away today at the age of 96. Justice Beevi was undergoing treatment for a prolonged illness at a private hospital in Kerala's Kollam. Justice Beevi had many feathers under her hat. Not only was she the first female judge at the Apex Court in 1989, she later went on to serve as the Governor of Tamil Nadu from 1997 to 2001. She was also the first Muslim woman to be appointed to the higher courts in India. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.